Welcome to the All Rise podcast, Sunday Scaries. I'm your host, Christine, a civil litigator and personal mentor. Every Sunday, we'll tackle those dreaded Sunday Scaries together to demystify the practice of law and provide you with actionable tips and guidance to face your week ahead. So grab a cup of coffee, take a deep breath, and join me while we turn those Sunday Scaries into stepping stones towards your success. Let's get started. Welcome back to the All Rise podcast, Sunday Scaries, where guidance ignites ambition. I'm your host, Christine Barker, and today we are diving in to part 3 of our 4-part series on case handling from start to finish. Today we're talking about settlement negotiations. We'll cover everything from selecting a mediator, the mediation process itself, and then drafting a settlement agreement. So let's get started. Last week we talked about creating discovery plans. And I mentioned that throughout the litigation process, there will be opportunities for resolution. Remember, 97% of all civil cases settle. So first things first is, number one, you need to find out if you've got an opportunity to settle. And like we said, if you've got a bad fact, you've got a good fact, you've got a good witness, you've got a bad witness. But being on the lookout for those opportunities. And that can happen throughout the course of a litigation and even pre-litigation. A lot of contracts will require that parties litigate before they can even file a lawsuit. As the associate, be sure that you're reading your contracts to determine if there is a pre-litigation ADR, alternative dispute resolution. And most contracts will tell you the jurisdiction. It might be AAA, the American Arbitration Association, it could be JAMS, or they might have some other private method that they want to utilize for their dispute resolution proceedings. Then we need to pick a mediator. The process of picking a mediator is unique, and this is going to be a third-party neutral who's going to help the two parties come together and find some sort of resolution. When selecting a mediator, there's a couple of things that you're going to need to take into consideration. Number one, experience and expertise. So this could be an attorney that's in the same field, like if you've got a contract negotiations, if it's construction like I do, I utilize a lot of attorneys who do construction litigation. I might use a professional in the industry. So it could be a contractor or an engineer or an architect. And then retired judges. You'll want to know and kind of take into account the personalities of the parties and the attorneys when you're selecting a mediator. It's also important to put together a list of several mediators. I like to do 3 to 5 and then present those to the other side. That way there's some negotiations on even who the mediator is. Also, reputation. Some mediators get a reputation being very plaintiff friendly or very defense friendly. Some mediators get a reputation for being numbers runners, where they just go into the room and they're like, hey, what number do you got? And they run it to the other side. Other mediators, have really great reputations of, a good bedside manner. Again, you need to take into consideration the parties that are involved and the personality of the attorneys. I have been in so many mediations where the personalities of the attorneys is what really screwed up the entire process. So keep those things in mind. Like I said, some mediators have a really good bedside manner. So if you've got a party who is very emotional, again, your business is law now. Your client's business is not. And a lot of times, this is the first time that they've ever been involved in any sort of legal dispute. So they're going to be emotional about it. So it's really important that if that is the case with any one of the parties, that you consider the bedside manner of your mediator, if they're going to be the type that are going to kind of hold their hand and let them tell their story. Because again, settlement and mediations, the goal is resolution. So your client or the other side are not going to have their day in court. This mediation is going to be their, quote, day in court. It's going to be their opportunity to tell the story. So make sure that if that's something that's important to your client, or you think that's something important to the other side, in order for them to get to a resolution table, keep that in mind when you're considering your mediator. Those are kind of stylistic characteristics of a mediator. And then obviously cost. Mediators can go for tens of thousands of dollars a day. And depending on the type of case, if you're litigating a multi-million-dollar construction matter, you may do 4 or 5 rounds of mediation, and they might go all day, and they might get staggered with which parties are coming in at which time. So you may need a more expensive mediator who's got that specialized expertise. But if you've got, say, a slip and fall and an injury case, you might not need somebody who is that robust. So keep in mind the value of the case, the value of the settlement, and the extent that you might need a more robust mediator, so that you can take into account the costs. As the associate, it's going to be your job to help prepare your partner and the client for the mediation. So the best thing that you can do, because you're going to be new to this process. So as a new associate, the best advice that I can give you is know the facts inside and out. Your partner, if you're mediating with them, if you get the opportunity to go with them to the mediation, and I suggest that you ask if you can shadow. I know my firm has opportunities for our new associates to shadow partners during mediations, depositions, law in motion, things like that. So ask your partner if you are able to go and shadow with them. If not, no big deal, not a problem. You've still got a lot of opportunities to learn in preparing a case for mediation. So you're going to want to know the facts inside and out. You're going to be the go-to person for what was the date that the accident occurred? Were there witness statements? Do you have a summary of the medical records? All of that stuff as the associate, you can organize and have that information available prior to the mediation. That's going to make you indispensable to your partner. Also, before the mediation, you're going to want to know, what are your client's goals? Is their goal to tell their story? Is their goal to resolve the case? Is their goal, and what do they want out of the settlement? If you're on the plaintiff side, you need to know, how much money that they're looking for. Do they need some agreements from the other side to do something or to not do something? Make sure you know your client's goals prior to the mediation so you can set expectations prior to the mediation and then throughout the mediation itself. Any documents, evidence that you think is going to be important, I like to open up a separate file folder on my computer and I drop documents in there. These are my hot docs. Like we talked about last week in creating that discovery plan, you've got your list of documents going. These are documents that are going to assist you in mediation, and if mediation is not successful, then in trial. So I like to drop these documents in there, highlight the portions that I think are important, things that I want to highlight during the mediation. This is, and again, as the associate, stuff that you can do beforehand to make the mediation process easier for your partner and for your client. Mediation briefs. A lot of mediators like you to do a mediation brief. And there's 2 camps in this mediation brief, is confidential briefs or briefs that you exchange with the other side. So, I don't know, if kind of way back in the day, I feel like confidential mediation briefs were kind of all the rage. And mediators don't really like them because if they're confidential and they're only going to the mediator, that's stuff that they can't share with the other side. Mediation is a confidential process, and mediators will constantly tell you that you can share things with the mediator, and if you don't want them to tell the other side that during the mediation process, you need to let them know. So, what I've started doing, and I have found this to be very effective in getting cases resolved, is I will do a brief that I'm going to exchange with the other side, and then if there's some confidential information I only want the mediator to know, I'll attach a page at the end that says, for mediator's eyes only, and then that'll be where maybe I'm saying the bad facts about my case, or maybe I'm telling him, where I think there's going to be problems. If I think that, that the other side is having client control issues. That might be where I tell the mediator, hey, look, I think our challenges are going to be, managing expectations of the other side. Or I may say, hey, look, I think the attorney's getting in the way of this resolution. And then I'd let the mediator know that. Another thing that mediators have been doing lately that I find is so helpful is they'll have pre-mediation conferences with each side prior to the mediation, maybe a day or 2 before, and they'll just do a quick conference call, get on, and then that's your opportunity to kind of tell your side of, tell your version of the case, outside of the presence of your client, because sometimes it might be your client that's going to be the problem at mediation, and the mediator needs to know that, but you don't want to say it in front of your client. So those are the opportunities I use to tell the mediator, hey, I have client control problems. My clients, I'm having a really hard time managing their expectations. I'm going to need you as the mediator to kind of lean on them a little bit. And then you're also going to prepare your strategy. Again, you're going to sit down with your partner and kind of come up with the strategy that you're going to utilize at mediation. What facts are you going to highlight? What information, what documents do you need? How are you going to handle the client? And then also determine if you've got what your settlement authority is. Is your client going to be there? I do find sometimes that it's helpful to have the client there, especially if they need to tell their side of the story. Sometimes it can impede settlement to have the client there, and sometimes clients just don't want to be there. I've got a lot of construction companies as clients, and sometimes they're like, hey, look, Christine, you know what we want. Here's the negotiations. Deal with it. Here's my cell phone. Call me if you need me. So again, all of these things, you're going to do this to prepare for the mediation, to make the mediation run smoothly and give it every opportunity for success. So the mediation process is going to vary because it's very informal. They're doing a lot of Zoom mediations now since the pandemic, but it could be in person, it could be on Zoom. Either way, it kind of functions the same way. So usually what will happen is you'll show up, the mediator will be there, you'll sit down, speak with the mediator. A lot of times, mediators used to do this where they would have a joint session where they would put everybody in one room together. And I think they've gone away from this a lot. I personally ask for us not to have a joint session if I think a mediator is going to suggest that or want that. The reason for me is mediation's an opportunity for you to resolve a case. Everybody's coming with the idea that they're going to settle. You put everybody in one room together where emotions may already be on high alert. Each side thinks the other side is wrong. And then sometimes mediators would ask the attorneys to do opening statements. I don't see this anymore, and thank goodness, because all it did was just ignite emotions between both sides, both the attorneys, because they're trying to be advocates, and to the parties because they're listening to all the holes in their case. And it really isn't a place of where people want to be in a mindset of resolution. So most mediators have done away with that. So usually what they'll do is they'll start you off in your own private rooms. So you're going to be in there. It's going to be you as the attorney. It's going to be your client. If you've got an insurance client as well, it could be a claims adjuster. And then the mediator is going to come in and let you tell your side of the story. And most of the time, because the client's never been through this before, the client's going to look to you to be their advocate to the mediator. The client's going to look to you to be their advocate. So have a good kind of concise statement of the case, what you want to present to the mediator. Or if you're there with your partner, listen. This is a great opportunity for you to kind of just soak up all of the knowledge and watch the different styles of how a mediator speaks. Again, we talked bedside manner, but some will come in and they'll be real jovial and, oh, how are things going on? And really kind of more of a friendly. Some mediators come in, I see this with a lot of retired judges, they come in very stoic and very, let's get down to the facts. Let's get going with this. So, but as the associate, keep your eyes open, watch and listen and learn. So during the mediation, there might be a few different types of strategies, and you'll be watching the mediator because they're going to be changing their strategy as they go along based upon what the parties are telling them. So actively listening, taking notes while the mediator is there. What is he saying? What information is he bringing in from the other side that he thinks is going to persuade you and your client to give a little on your side? So keep an eye on those things and take notes and really actively listen to that. While you're doing that, also think of the counterpoints, things that you need to be pointing out to the mediator about your case. Know that the goal is for both sides to give a little. So know that going in and make sure your client knows that going in, because I mean, it's a non-starter if parties come in, dig their heels in, and say, just give me everything that I've asked for, or there's no resolution. That's the quickest way to end a mediation and be on with your day. Make sure that you and your client are focusing on interests, not positions. Identify the underlying interest of both parties rather than sticking rigidly to your initial position. Again, this goes along the lines of being flexible, that the point of the mediation is to come to some common ground, some middle ground between the two parties. Use objective criteria. Use facts. When I make offers in a mediation, I like to have them to have some sort of basis. So for example, if I'm working on an injury case, I'll take a look at what their medical bills were. And I'll say, okay, here's how much they paid out of pocket for their medicals. Here's how much they, claim that they're going to need in future medicals. I'll use those numbers as my starting point. If I'm going to challenge whether they need future medical treatment, or if I'm going to challenge whether the treatment they received was reasonable and necessary, then I can start saying, hey, you know what? I think that, the physical therapy was reasonable and necessary, but the 5 epidurals were not. And then it makes it easier for me to say, I'm not going to pay for those in my first offer. So use objective criteria when you're trying to devise what the first offer or next offer is going to be. Make sure that you understand whether attorney's fees are recoverable in your case. So many times I have found where cases get stuck and unable to resolve because there's attorney's fee provision, and people just kind of dig their heels in. Who's going to pay for my lawyer? Stay calm. Try not to kind of rise to the occasion, especially if you're hearing bad facts about your case, your client is upset. It's your job as the attorney to help manage expectations, manage emotions. Now, that doesn't mean I don't get a little feisty sometimes during mediation, because I need for my client to see that I'm passionate about their case. So there will be times that, you'll see me spark up a little bit in mediations because I am passionate about my case. I do want to advocate for my client's position, but there's a time and a place to do it. And so just be mindful of that. Again, if you're mediating with your partner, watch how they're doing it. See if there's some things that you like about their style and things that you don't like about that style, and then you can incorporate that later on. Some tools to kind of, or some maybe buzzwords to kind of be, to be on the lookout for during mediation is mediators will use words like midpoint. That means what they're talking about is if you take your offer, their offer, add them together, divide them in half, that's the midpoint. A lot of times, if you're not watching, that's where the negotiations are doing. That each side is targeting to a midpoint. So if, for example, you have $100,000 in settlement authority and the other side comes in and their demand is $1 million, you want to make sure that your offers do not track a midpoint that is higher than what your settlement authority is. Now, just because you've got $100,000 in settlement authority doesn't mean that's where it's going to settle. But you want to make sure that when you're making offers at the beginning, that you're indicating to the mediator and to the other side with your offer where your point of no return is. It's not going to be over $100,000. Again, you might have to settle for more, but in the beginning, it's setting expectations for the mediator and for the other side. Now, if you're fortunate enough to reach a settlement during your mediation, and again, it might take several rounds to do this, but if you're fortunate enough to reach a settlement in the mediation, lots of mediators, especially if it was a contentious mediation and kind of difficult to get to, will want you to sign a settlement agreement right then. I think this is absolutely key, especially again if you've got highly emotional parties on either side. So one thing is really important as the associate, come with a settlement agreement beforehand. A lot of the terms are fundamental terms. Things like, is there going to be a confidentiality provision? Is there going to be attorney's fee provision if someone has to enforce the settlement agreement? Where payment's going to be made? You can do the recitals about what the case is about. The release language. A lot of jurisdictions have kind of standardized release language. For example, in California, we've got Civil Code 1542. Most settlement agreements, and if you're practicing in California, I would encourage you to always put this into your settlement agreement, will include a 1542 waiver, which basically means that both parties are waiving all of the known claims they have between each other and all of the unknown claims they have between each other. This is really important for parties to kind of buy their peace of mind with the settlement and know they're never going to have to revisit any of the potential claims that could have arose out of this particular dispute. Another key term that you can make sure is already in the settlement agreement before you ever get to the mediation is an alternative dispute resolution provision. Are you going to say that you need to do ADR before you can file a lawsuit to enforce the settlement agreement? Remember, the settlement agreement is a new contract between the two parties, so you're going to want to make sure that the key details of that relationship between those two parties under that contract are spelled out. Now, some jurisdictions, California being one of them, has what's called a good faith settlement determination. This is a motion or an application that you can make to the court, and where you let the court know that this was an arm's length transaction between two parties. There was no collusion, and that the settlement is, quote, within the ballpark. That's a term of art in California with respect to good faith settlement motions, but that you are within the ballpark of potential liability exposure. The reason that these can be really, really important is that, say for example, you are one defendant of multiple defendants. California has joint and several liability, which means that in a tort matter, if you are found 1% liable, if a defendant is found 1% liable, they are on the hook for all of the plaintiff's damages that arise out of their negligence. So the reason that this is important, the reason that it kind of dovetails into good faith settlement motions is that if you get your settlement blessed by the court says, yes, your settlement was made in good faith, it cuts off the opportunities for any other party to sue your client for equitable indemnity or contribution. Now, it doesn't cut off breach of contract because that is agreements made by two parties. But for any equitable causes of action, it does. So make sure that you've got that in mind when you are negotiating your settlements, so that if you do need a good faith settlement motion, you can put it into your settlement agreement. Some other tools that you can utilize in your tool chest of settlement negotiations, some jurisdictions have offers to compromise. These are statutory offers to compromise where you make a formal offer to the other side. It has to be accepted within so many days. And if it's not, it has fee shifting opportunities at the time of trial. They're very specialized. They vary jurisdiction to jurisdiction, but check it out. Maybe it's a tool that you can put into your toolbox for your next settlement negotiations. Thank you so much for joining us today on the All Rise podcast. If you found this episode helpful, please do like and subscribe. Leave us a review. All of that really helps me out. I appreciate it. And until next time, keep rising.